5 Ways Modern Grave Robbers Hurt Your Family. Presented by Gregory P. Hawkins, the lawyer. All rights reserved.
Without proper preparation, modern grave robbers will steal from your family time, money, choice, privacy, and peace. Not peace of mind, but peace. In over 33 years of legally preparing thousands of people for death, and in fighting the battles in and out of court of those who failed to prepare, I have seen just about every folly and tragedy failure to prepare can bring. The widow who spent $150,000 of the $450,000 estate in attorney's fees and over 2 years in court to fight off what she thought were loving family members. The financial planner who died slowly of cancer but failed to prepare. His profession was teaching others to prepare. His wife, a second marriage, had nearly a year-long expensive battle with her own family. The clients, almost too many to number, who decided to prepare but waited. Too long and tragedy struck. Expensive, time-consuming, contentious tragedy. Failure to plan is the very definition of modern grave robbers. Proper planning can eliminate conflict, great expense, and wasted time. Your legacy is not your money or your property. Your legacy is your family and the sweet, tender connections they have. Protect that legacy. Did you know that most, not some, but most people in this country fail to plan at all? Over half. Some studies say that as many as 69% of people fail to properly plan for the inevitable. Here's what happens if you fail to properly plan. In many states, the state legislature has passed laws to help cushion the pain of their citizens who fail to plan. These states have created a two-track system of probate: informal probate and formal probate. Formal probate requires litigation and is very expensive, contentious, and time-consuming. Informal probate is the cushion, the help the state legislatures have created. With informal probate, you spend a minimum of 6 months in a court-involved process. Most find it necessary to have the aid of a lawyer, but the fee will only be about $3,000, compared to the tens of thousands needed for formal probate. You can see the cushion. Besides the time and the minor expense, informal probate is public, and by its very process, invites conflict. If there is a question, or an issue, or a problem that must be resolved by the judge, the informal probate process will be changed to formal probate, and then you're off to the battle. Time, money, contention. Who must go to probate? If you die with or without a will and own real estate and fail to otherwise plan, you will go to probate. Here's something many people do not know. If a will is used, it must go to probate. There is no will that does not have to go to probate. Every will must be probated. If a will does not go to probate, it has no legal force or effect. None. Now you may be thinking, my aunt had a will and we did not go to probate. One of two things occurred. One, you actually did go to probate and you did not know it. Or two, you did not use the will legally. A will cannot be used legally without probate. A will has no legal force or effect without probate. And if you're one of more than 50% of this country who has done nothing to prepare and you own real estate, including your home, probate is required to pass title to that real estate for the next generation. But here's the catch. If you did nothing to prepare, then upon your death, you have no choices. You cannot choose who is in charge of your estate, and you cannot choose how your estate is distributed or divided up. If you have any special circumstance with your family, it does not matter. You have no choices. By not preparing, you made a direct invitation to modern grave robbers to hurt your family. What is the best way to pass your estate to the next generation? What is the most flexible way to pass your estate to the next generation? What is the most efficient way to pass your estate to the next generation? What is the least expensive way to pass your estate to the next generation? It is the revocable, living trust-centered estate plan. I have never met a lawyer, a financial planner, an accountant, or other professional that was experienced in this subject matter, that of legally preparing for death, that did not agree 100% that the trust-centered estate plan is the best, most flexible, the most efficient, and least expensive way to legally prepare for death. What is the revocable living trust-centered estate plan? Whether you live in Delaware, Florida, Nebraska, California, Montana, Texas, Hawaii, or anywhere in the country, the trust-centered estate plan consists of 6 documents: the trust, pour-over will, the durable power of attorney, the healthcare directive, the living will, and the deed to your real estate. What is a trust? A trust is a contract, recognized and effective in all 50 states and internationally. The person who sets up the trust is called the settlor, sometimes referred to as the trustor. The IRS refers to him or her as the grantor. The other party to the trust contract is the trustee. It is the trustee who administers the trust by following the terms of the trust. Why does the trust not have to go to probate? When you're using a trust to prepare for death, the settlor, trustor, the grantor of the trust, and the initial trustee are usually the same person. When that person dies, the trust stops being revocable and becomes irrevocable. And a new trustee, the person who administers the trust, steps into the trustee's position under the terms of the trust contract. The new or successor trustee now follows the terms of the trust and distributes the assets of the trust to the beneficiaries or to the deceased's heirs. Under the law, the trust is considered a person, a legal entity, but the trust does not die, so there is no probate. There is no time-consuming legal process. There is no public process. And if the trust is artfully, skillfully, and well-written, there are no taxes, contention, or expense to distribute the estate and close the trust. It is flexible, efficient, very inexpensive, and the best way to legally prepare for death. Now, there is a critical, vital, and highly important aspect to the preparation of the trust. Let me illustrate with a story. My granddaughter, Lily, invited me to the garage to see the painting she had created. She was 7. I looked at the painting, and as with all grandfathers, I felt charmed by her efforts. But I also could not really tell what she had painted. It was kind of a mess. About 10 feet away among the normal debris in the garage was a print of a very nice Monet. It might actually have been a Van Gogh, but I was struck by its beauty, its use of color, its vibrancy. I approached and looked closely. Even the brushstrokes captivated me. I looked back at Lily's and then to the Monet, and I, of course, could see the difference, but Lily could not. It's the same with the trust. Just because Lily calls her painting art does not make it so. Just because a document is called a trust, it does not make it proper legal preparation that will avoid taxes, contention, expense, etc. The worth, the value of a trust is in its words. It must be skillfully, artfully written by an experienced lawyer who by that experience has refined its terms in the very crucible of conflict and the passing of many clients. There are Lily trusts and there are Monet trusts. The only way to avoid problems, to avoid modern grave robbers, is by using a Monet trust. Let me share with you a couple of insights that illustrate the difference between a Monet trust and a Lily trust. The trust must be comprehensive. Comprehensive means it must take care of the future without knowing what the future will be. An example. Most people do not have heirs with a disability who receive government assistance. But what of the future? An accident, an illness. One or more of their heirs may find themselves on government assistance, like supplemental security income or Medicaid. That heir may be limited in the amount of money he or she may be able to receive, including an inheritance. But here is what most people, including many lawyers, do not know. In the 1990s, Congress passed many laws benefiting people with disabilities. One of those laws allows you to leave an inheritance to an heir with a disability, known or unknown, without affecting their government assistance. But the vehicle in which you must leave the inheritance is called a supplemental needs trust or a special needs trust. Most, and I mean the vast majority of trusts, do not take advantage of this law benefiting people with disabilities. A Monet trust does. Another example of a comprehensive trust. What is to be done with a contentious heir or fake heir? More than 70% of the thousands of trusts I have reviewed do not even have a basic non-contest clause. But even if they did, a basic non-contest clause only lets you win at the end of the contest. A Monet written non-contest clause will allow you to stop the contest before it even begins. There are probably 24 terms written into a well-drafted trust, a Monet written trust, that takes care of the future without knowing what the future is, written into a comprehensive trust. A Monet trust will be administratively easy. It'll be easy for the person setting it up and those administering at death. It will not require the need of a lawyer to administer it, either before or after death. It will be easy for your family. A Monet trust will be cost-effective. It will be inexpensive to set up and cost-free, or nearly so, to administer upon death. The trust is the most important part of the trust-centered estate plan. It should be carefully, skillfully, and artfully written by a lawyer with much experience in the arena that surrounds legally preparing for death. This is not a task for the novice or for a lawyer whose primary focus is not on this area of law. While the trust is the most important of the 6 documents making up the trust-centered estate plan, the pour-over will is the least important. The sole purpose of the pour-over will is as a precaution. It exists only to be used if an asset is left out of the control of the trust. For example, you purchase a new parcel of real estate but neglect to transfer it to the trust. You die. Now that parcel must be transferred to the trust. It is the pour-over will that will be used, through probate, to make the transfer. Remember, it is intended that the pour-over will never be used. It is a precaution only. What is a durable power of attorney? A power of attorney is a document in which you appoint someone to act for you. If it is durable, that person continues to act for you, even if you lose the capacity to make your own decisions. Durable powers of attorney are powerful legal documents and can be very useful, especially when they are part of a trust-centered estate plan. Durable powers of attorney are effective in all 50 states by statutory law. While living, this document may be the most practical of the 6 documents. It is very helpful, even essential, if you become mentally incapacitated. What is a healthcare directive? A healthcare directive allows you to appoint someone to make healthcare decisions for you if you're unable to communicate. A properly written healthcare directive will avoid delay and contention at a time you want no delay or contention. What is a living will? This is probably the document that appears most often in the news. The living will can direct physicians to stop life support that is unnaturally keeping you alive if your condition is terminal. It shifts the burden of decision from healthcare providers to you. You can make this decision for yourself in advance for the future, or you can appoint someone in whom you have confidence to make that decision at the time. This wonderful legal document can save great emotional stress on your family as well as untold resources. Why is the deed included as one of the 6 documents of the trust-centered estate plan? All real property, real estate, should be transferred to the trust by properly drafted deeds. There are many types of deeds: warranty deeds, special warranty deeds, grantor deeds, quitclaim deeds, and others. Each deed has different requirements and different consequences. Trust lawyers often use the quitclaim deed as the deed of choice to transfer your real property to the trust. The quitclaim deed, in many circumstances, is more flexible and allows you to avoid problems. The last issue in this short discussion is what I call the Mayflower moving truck problem. This is simple. It is the idea that we have no idea at all when we will die. One person every 4 minutes passes unexpectedly, not from sickness or age, but unexpectedly. Proper legal preparation is available. It is affordable, and for most of us, it is absolutely necessary and wise.
Thank you for watching our presentation, 5 Ways Modern Grave Robbers Hurt Your Family. Gregory P. Hawkins is a lawyer whose practice focuses entirely upon trust-centered estate planning. He is a nationally recognized lawyer who has been accredited as an estate planning expert. With decades of experience, his clients include judges, lawyers, accountants, financial planners, insurance agents, and thousands of others. Greg Hawkins' articles have been published in over 40 periodicals, and he has authored 7 books, 3 on trust-centered estate planning written just for lawyers, and 3 on public, social, and private ethics.